I now call to order the Committee on House Administration for purposes of today's hearing titled Preventing Sexual Harassment in the Congressional Workplace, Examining Reforms to the Congressional Accountability Act. The hearing record will remain open for 5 legislative days, so members may submit any materials they wish to be included. A quorum is present, so we may proceed. I ask for unanimous consent that Committee on Ethics Chairwoman Susan Brooks, Representative Jackie Spear, and Representative Bradley Byrne be afforded the opportunity to sit on the dais and question all of our witnesses today. Without objection, so ordered. At the outset, I would like to thank all of our witnesses for taking time out of what I know are very busy schedules to be here. We're much appreciative of that. First and foremost, let me reiterate, there is no place for sexual harassment in our society, especially in Congress, period. And one case of sexual harassment is one case too many. The Speaker of the House, Paul Ryan, tasked this committee with heading up an extensive review on this issue, and we take that responsibility very seriously. As members of Congress, we must hold ourselves to a higher standard, a standard that demonstrates that we are worthy of the trust placed in us by the public, by our constituents, and by everyone in this country. Since our last hearing on November 14th, additional accounts of sexual harassment have surfaced and questions about the related settlements, both those authorized under the Congressional Accountability Act and outside that act have been raised. These issues suggest not only that it is time, but it is appropriate for the committee to review the policy goals of the Congressional Accountability Act, review the processes set out in the act, what we need to do to accomplish those policy goals, and evaluate the reforms needed to accomplish our collective goal, our bipartisan goal of zero tolerance. The Congressional Accountability Act has not been comprehensively reviewed since its enactment in 1995. The House took an important step forward last week in updating its policies and procedures by passing HRes 630. This resolution requires all House members, officers, employees, including paid or unpaid interns, fellows, and detailees, to complete anti-harassment and anti-discrimination training every year, as well as require all House offices to post a notice of employee rights and protections under the Congressional Accountability Act. The logical next step is to conduct a closer review of the Congressional Accountability Act to identify and evaluate what reforms are needed to ensure that we are protecting all congressional employees and the workplaces. This hearing plays an important role in our committee's extensive review, and the insight from our witnesses today will help inform us and help us make those policy choices. I want to take this opportunity again to thank our Speaker, Paul Ryan, for tasking our committee with this important issue. I would also like to thank the Ranking Member, Bob Brady, for his commitment to this issue and having the House work in a bipartisan manner. Not only is it essential, it's what people expect. I look forward to hearing from each of our witnesses today, and with that, I'll yield to the Ranking Member, Mr. Brady.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for calling this hearing today and for the bipartisan manner by which you are approaching this issue. I also want to thank our witnesses, especially from the House Employment Council and Office of Compliance. I appreciate the professional and nonpartisan way you approach your jobs, and thank you for being here for a second time. The Congressional Accountability Act needs to be reformed. Since our last hearing, I have met with my colleagues and experts to better understand how we can improve this legislation. But most importantly, I met with survivors of the sexual harassment and assault. We need, Mr. Chairman, we need to improve this process. But most importantly, we need to change the culture of this place, and that change must start with us. I hope this hearing helps us find some agreement on what we must do and help us better understand how we can reform the Congressional Accountability Act and give victims more confidence in the process and justice for the terrible experience that they have endured. We owe it to our employees and the American people to get this right. Mr. Chairman, I look forward to hearing from our witnesses, and I yield back the balance of my time.
Thank you, Mr. Brady. Does any other member wish to be recognized for the purpose of an opening statement? Chair will now recognize gentlelady from Virginia, Ms. Comstock, for purposes of an opening.
Thank you, Mr. Chairman. And again, I appreciate your leadership and Ranking Member Brady and the bipartisan, bicameral nature with which we're approaching this. And I do really believe that this is a watershed moment, and we need to take this opportunity to really fundamentally change how we address this in Congress, but also beyond. I thank my colleagues, Jackie Spear and Bradley Byrne, who are also joining us today, and I believe Susan Brooks, chairman of the Ethics Committee, will be joining us too. 30 years ago, a young woman, Dorina Bertucci, was the first victim of sexual harassment who brought this forward, highlighted this issue against a member of Congress, and prevailed in her case. She is here today, and I want to welcome her and once again thank her for her courage and her perseverance and how gracefully she handled a terribly difficult situation then. And I think it's important that now, even though it's far too long, and it shouldn't have been this long, that we do right by Dorina, but all the other people who are the people behind many of the headlines that we're seeing right now. We see often the offenders, and certainly we want to know about sexual predators because we know sexual predators cross all party lines. Their actions transcend any party labels. But we want to make sure that the victims are put first and foremost here, that we provide a advocate for them, whether it's a counsel or an ombudsman or some type of more level playing field so the victims feel that we are protecting them, but also more importantly that we actually are and that we make this a much more fair system. Again, and also in that arena, how we address the non-disclosure agreements. We know the non-disclosure agreements are often preventing us from really knowing what's going on there, and whether it is allowing people in the past here in Congress to be able to come forward without any fear of violating their non-disclosure agreements, or how we address it in the public sector in general. I know there's legislation on that front too, so I think that's an important issue that we all need to address going forward. So thank you for the opportunity here to have these expert witnesses, and particularly the EEOC did a report last year, which I found very helpful in terms of they're talking about changing the culture and how we do that by permeating from the top down, from the bottom up, and that this really needs to be something where we're all engaged and involved. So thank you for the opportunity today to address this important issue.
Gentlelady yields back. The chair will now recognize the gentleman from Maryland, Mr. Raskin, for the purposes of an opening statement.
Mr. Chairman, thank you very much. Mr. Brady, thank you both for convening this very important hearing, and I want to thank our colleagues, Representative Spear, who has been in the forefront of the new changes that we're making, Congressman Byrne, and I think also Representative Brooks is coming or on the way. We are in the middle, Mr. Chairman, of a dramatic culture shift that is a tribute to the women's movement in the United States and also to the strong political democracy that it's part of here in our country. The public uproar over sexual harassment and sexual assault began in other places. It has rocketed across America. It came to the halls of Congress, and it has shaken this institution to the core. But I am pleased that this is a moment when we are restating our common bipartisan commitment to zero tolerance for sexual harassment and to a safe, dignified, and equal workplace for everyone who comes to serve Congress. And we are doing this on a bipartisan basis. We're doing this on a comprehensive institutional basis. And I think that's the value that's being vindicated. This is a culture shift, much like ones Congress has gone through before. It used to be that lobbyists could give members of Congress gifts and take them out for dinner and on fancy trips, and then there was a public uproar, a scandal, a rule was passed that banned it, and now it's unthinkable in this culture. It used to be that members of Congress could pocket money from their campaign funds when they retired, and there was a scandal, public uproar, a rule against it, and it's unthinkable that anybody would do that today. We simply need to make sexual harassment something that's unthinkable, that just wouldn't be done within these halls. So that's the value. I think everybody agrees with it. What we need is a process that implements that value. And of course, the devil is in the details. We need rules that will strongly deter sexual harassment, and we need a process in place that will swiftly and fairly punish sexual harassment, address the situation of victims, and get to the facts of cases that are controverted until we really can move to a time when sexual harassment is simply no more in this body. But I'm glad that we're all part of this. We're going through this process, which is obviously painful for some members of this institution, but we have to leave sexual harassment behind the way we've left other sordid practices behind. And I'm proud that the House Committee on Administration is playing a leadership role there, and that we have so many colleagues who've come to join us in that project. I yield back to you, Mr. Chairman.
Gentleman yields back. Anyone else have an opening statement? Chair will now recognize Ms. Spear for the purposes of an opening statement.
Mr. Chairman, thank you. And I, too, applaud your efforts in the bipartisan manner in which we have undertaken this issue, to Ranking Member Brady, to my colleague, Ms. Comstock, and to my colleague, Mr. Byrne. I think we are at a watershed moment, as you said, Mr. Chairman. You know, I've been working on this issue for a very long time. Long before I came to Congress, as a matter of fact, in the mid-1990s, I was chair of the Women's Caucus in the state legislature, and we had a hearing on this issue. We brought in Dr. Frances Connolly, who was the first tenured neurosurgeon in the United States, and she was a professor at Stanford University. And she wrote a book called Walking Out on the Boys and talked about the horrific environment in which she had to work as a professional in academia and as a medical professional. Of course, the Anita Hill hearings of 1992 was also a watershed issue and time when it was called the Year of the Women. Well, it was 1 year, and that, frankly, was not enough. So what we have experienced over the last many decades is that there has been a return to the status quo, which is woefully unacceptable. We all recognize now that the Office of Compliance is mandated to do things that really hurt the victim. It's not that they do it by choice, it's because that's how it is mandated in the Congressional Accountability Act. H.R. 4396, which some of you have co-sponsored, it now has over 110 co-sponsors, it's Republicans and Democrats alike, is the Me Too Congress Act, which attempts to do the job of reforming the Office of Compliance. I don't think it goes far enough. And as we continue to talk about this issue, I think we need to recognize that probably the House Ethics Committee or the House Administration Committee is not the venue to which investigations should be sent when a complaint is filed about sexual harassment. There needs to be an independent investigation. Now, some have said, well, how about the due process? And I would say, you know, there is due process here, and if we allow this independent agency or entity to do the review and make a recommendation to the House, that would provide it. I do think that we have to recognize that behavior like this is normally not just one incident. Normally, it's a pattern of behavior. And I think we've got to make sure that however we move forward, that we are victim-centric. We have to recognize that many of these victims, one of whom sat in my office crying, said to me, going through this process was worse than the sexual harassment itself. Shame on us for not having addressed this sooner. But I want us to remember a young woman who came to this building, who worked in a number of offices, and it was in her second office where she became, or where she filed a complaint for sexual harassment. She's no longer here. Her career was over. She was told her career would be over if she filed the complaint, and she hasn't worked since. We've got to make sure that the victims have the opportunity to stay here and work. They have a right to be able to work in these hallowed halls. just because they were pawed by a colleague of ours or by a staff member is not a reason to then, if they file a complaint, to ostracize them. So as we talk about this, I hope that we will redouble our efforts to make sure that we are protecting the victim and that we are making sure there's a soft landing for them so they can continue to pursue a career in public service. With that, I yield back.
Gentlelady yields back. Chair will now recognize the gentleman from North Carolina, Mr. Walker, for purposes of an opening statement.
Thank you, Chairman. I appreciate the opportunity to be part of this committee, and I think it says much that the Speaker has chosen your leadership in this committee to handle a sensitive but very important matter. I think about the bravery of all the victims that have stepped forward. I believe Congresswoman Spears is exactly right. There is a pattern to this behavior, certainly much of the time. But it usually takes a champion or someone to step forward to begin to break through some of that, who's willing to come out. And we actually have one of those leaders in this courage movement, Gretchen Carlson, with us today. So I just want to acknowledge her bravery over the last couple of years in being a leader in this movement. With that, I yield back, Chairman.
Gentleman yields back. Any other person wish to be recognized for the purpose of an opening statement? I'd now like to introduce our witnesses. First, Victoria Lipnick was appointed as acting chair of the U.S. Equal Employment Opportunity Commission by President Trump on January the 25th, 2017. Before becoming the acting chair, Lipnick served as the commissioner. Acting Chair Lipnick has extensive experience working with federal labor and employment laws, holding positions such as U.S. Assistant Secretary of Labor for Employment Standards and Workforce Policy Council to the Committee on Education and the Workforce in the U.S. House of Representatives. Acting Chair Lipnick has also worked in the private sector as counsel to the firms Seyfarth, Shaw, LLP, and its Washington, D.C. office. We welcome you, Ms. Lipnick. I'd also like to introduce Susan Swee Grundman, Executive Director, Office of Compliance. Ms. Grundman serves as Chief Operating Officer for the Office of Compliance, which was established to ensure the integrity of the Congressional Accountability Act of 1995 through programs of dispute resolution, education, and enforcement. Ms. Grundman also works with the Office of Compliance Board of Directors to advise Congress on needed changes and amendments to the Congressional Accountability Act. Previously, Ms. Grundman served as the chairman of the U.S. Merit Systems Protection Board, enforcing federal merit systems in the executive branch. She was confirmed to that position by the U.S. Senate in 2009. Ms. Grundman has more than 20 years of professional experience in litigation and in advising and educating clients in labor and employment matters. She began her legal career as a law clerk to the judges of the 19th Judicial Circuit of Virginia. Welcome, Ms. Grundman. Ms. Gloria Lett currently serves as counsel to the Office of House Employment Counsel. Prior to serving as counsel, Ms. Lett was a corporate attorney handling employment law issues and litigation for a large telecommunications company. She also served as an assistant corporation counsel representing the District of Columbia in civil litigation, as a special assistant United States attorney for the District of Columbia handling criminal prosecutions, and as an attorney for the Equal Employment Opportunity Commission. We welcome you, Ms. Lett. Dan Crowley has served as counsel to the firm K.L. Gates in the firm's Washington, D.C. office since 2008. Prior to joining K.L. Gates, for 5 years, Mr. Crowley was Chief Government Affairs Officer at the Investment Company Institute, the National Association of the Mutual Fund Industry. Previously, Mr. Crowley was Vice President and Managing Director of the Office of Government Relations at NASDAQ Stock Market, Inc. Mr. Crowley's earlier employment includes counsel to this committee, the Committee on House Administration, also the Committee on House Oversight, and the Office of Speaker Newt Gingrich. We welcome you, Mr. Crowley. The committee has received each of your written testimonies, and you will each now have 5 minutes to present a summary of that submission. Of course, most of you have testified before or seen that, so you have the clock in front of you that will help you keep up with your time. When you have gone, it'll be green for 4 minutes, then it'll turn yellow for the last minute, and red means that your time has expired. So the chair now recognizes our witnesses for the purpose of the opening statement, beginning with the EEOC Acting Chair Lipnick. Thank you both. Thank all 4 of you for being here today.
Thank you so much. Chairman Harper, Ranking Member Brady, members of the committee, good morning, and thank you for the opportunity to testify before you today about a subject that for weeks now has consumed headlines, sexual harassment, but certainly something that we at the EEOC have known to be far too common and which is only now being fully brought into the light. Since early October, when news of what was then simply known as the Weinstein scandal broke, the issue of sexual harassment has dominated the nation's collective conversation. I am pleased to add my voice to that dialogue this morning. By way of introduction, as the chairman said, I'm Vicki Lipnick. I'm the acting chair of the U.S. Equal Employment Opportunity Commission. I've served as a commissioner of the EEOC for the last 7.5 years, and President Trump designated me acting chair in January of this year. When I first joined the EEOC in 2010, I was struck by the number of harassment complaints the agency would see every year, the cases we would litigate, and the egregious behaviors we were addressing on behalf of victims of harassment. I had a conversation with our then chair, the late Jackie Berrien, who asked me to dig deeper into this issue. I spoke with every one of our district directors around the country and each of our regional attorneys. I was astonished, but also deeply concerned that, to a person, I was told the same thing. The EEOC could, if it wanted to, have a docket consisting of nothing but harassment cases generally and sexual harassment cases specifically. This fact and the concern on a leadership level with the persistence and pervasiveness of the harassment claims we at the EEOC continued to see led to the establishment of the Select Task Force on the Study of Harassment in the Workplace, an outside group of experts that the EEOC convened following a public commission meeting on workplace harassment in January 2015. I was honored to co-chair the Select Task Force alongside my Democratic colleague, Commissioner Hy Feldblum, who joins me in the hearing room today. The goal of creating the task force was to see if we could find new, innovative ways to address workplace harassment. We wanted to speak to and reinforce the work of prevention, not just address, as an enforcement agency, liability issues. The task force included members of both the management and plaintiffs' bar, organized labor and trade associations, academics, including social scientists, compliance experts, and worker advocates. Our work concluded in June 2016 with the release of the final co-chair's report, almost 30 years to the day after the United States Supreme Court handed down its landmark decision, Meritor Savings Bank versus Vinson, in which it held for the first time that sexual harassment was a form of unlawful sex discrimination. We took away a number of top-line lessons learned through the study of the task force, which I would take this opportunity to share. First, workplace harassment remains a persistent problem. Almost fully 1/3 of the approximately 90,000 charges received by the EEOC in fiscal year 2015 included an allegation of harassment. This includes charges of harassment on the basis of sex, race, disability, age, ethnicity, national origin, color, and religion. Second, workplace harassment, particularly sexual harassment, too often goes unreported. In fact, the least common response to harassment is for an employee to take some formal action, either to report the harassment internally or file a formal legal complaint. These employees may not report harassing behavior because they fear disbelief or inaction on their claim, blame, or social or professional retaliation. Third, an effective anti-harassment effort must start at the top, and leadership and accountability are crucial. This cannot be overstated. Effective prevention efforts and workplace culture in which harassment is not tolerated must start at the highest level of management, and an organization must have systems in place that hold employees accountable for this expectation. Finally, training must change. Much of the training done over the last 30 years has not worked as a prevention tool. It's been too focused on simply avoiding legal liability. We believe effective training can reduce workplace harassment, but even that cannot occur in a vacuum. It must be part of a holistic culture of non-harassment. And one size does not fit all. Training is most effective when tailored to the specific workplace and to different cohorts of employees. I understand that the committee is contemplating changes to procedures designed to address workplace harassment in the legislative branch. I'm happy to offer my thoughts on these proposals. In the interests of giving the committee full background, my written testimony includes a lengthy discussion of the EEOC's procedures with respect to discrimination charges in both the private and federal sectors. I would also commend to the committee a set of promising practices for preventing and combating workplace harassment that the EEOC recently published on our website and which have been provided to committee staff. In closing, I reiterate a key finding of our task force report. No system of training, monitoring, or reporting is likely to succeed in preventing harassment in the absence of genuine and public buy-in from the very top levels of an organization. We can and we must do better in all of our workplaces. I'm pleased to answer any questions you may have. And as you said, Mr. Chairman, I'm a former House staffer myself, so I'm very familiar with working in the legislative branch. Thank you.
Thank you very much, Ms. Lipnick. The chair will now recognize Ms. Grundman for the purposes of her opening statement. You're recognized for 5 minutes.
Good morning, Mr. Chairman, Ranking Member Brady, and distinguished members of this subcommittee, committee, and guests. On behalf of the Office of Compliance and our entire board of directors who joined me here today, thank you for the opportunity to discuss our process and our concerns. We support and commend the efforts of this committee and the members of Congress for mandating workplace rights training for everyone and notice posting of those rights. Over the last 6 weeks, we have seen a triple-digit percentage increase in the number of requests for in-person sexual harassment prevention training, a triple-digit percentage increase in the number of staffers enrolling in our online training module, twice as many visits to our online information about how to report sexual harassment, a 12% surge in the number of people subscribing to our social media platforms to receive updates on rights and protections, and I am happy to report that posters notifying employees of their rights are flying off our shelf with reorders arriving late last week. These numbers tell us something. They mean that people are finally taking seriously the problem about which we've been sounding the alarm and have been proactively working to combat for years through our outreach and education program. However, mandatory training and posters are the floor, not the ceiling. And even though Chair Lipnick notes in her statement that the training in the last 30 years has not worked as a prevention tool, we've over 20 years of non-mandatory training, and here we are today. To reach the ceiling, not only should our process change, which we hope to discuss with you today, but as the chairman noted previously, publicly and forcefully, that the culture must change. And that cultural shift includes not just changes to our process, but a shift of a policy, a sexual harassment prevention policy that is currently not mandated under the law. That policy should include examples of what constitutes harassment, reporting procedures, standards of conduct, investigations at the appropriate level, and accountability. This discussion is proof that the members of this committee in this watershed moment are validating, focusing on an issue and validating our efforts to help build a strong culture of collegial respect. Let me note, media reports have portrayed us as opaque, Byzantine, shrouded in secrecy. And while we understand that these comments are directed at our process and not to us as individuals, these comments nonetheless sully the reputations of the 20 women and men who faithfully report to our office every day for work, including our occupational health and safety inspectors who examine the Capitol grounds for hazards and public access, including our deputy executive director who trained 500 people in person over the last 6 weeks, and not all at once, but in ones and twos and tens, and including our only alternative dispute resolution counselor who meets with employees at the beginning of the process to hear their stories, to advise them of their rights, and to comfort them in their distress. This is the process that Congress designed in 1995. a process that not only demands confidentiality, but strict confidentiality under the law, a system we've been tasked to administer, a process that Congress is now seeking to change, and a change that we welcome, and we hope that we will play an integral role. Many call this a moment of reckoning. We call it a moment of clarity. A clarity with respect to not what we do, but what we do under the Congressional Accountability Act. And as you deliberate, we ask that you bear in mind that this is a new day, not just for Congress, but throughout the legislative community. The changes that you propose and implement should and must apply beyond the halls of Congress and to our entire legislative community. During this time, our office stands ready, and we will roll up our sleeves to assist you in the important work ahead. Thank you. I look forward to your questions.
Thank you, Ms. Grundman, for your testimony. We look forward to asking you some questions soon, and we'll now recognize Ms. Lett, counsel for the Office of House Employment Counsel. Welcome, Ms. Lett.
Good morning. I want to thank the Committee on House Administration for inviting me for a second time to give testimony on the issue of preventing sexual harassment in the workplace. This testimony will supplement the written testimony that I submitted to the committee earlier this week. I want to start by referring to an opinion piece I read on the cover of the Washington Post yesterday. It was entitled, "I Was Sexually Harassed, Question My Story." It was written by a woman named Carissa Fenwick. In the article, Ms. Fenwick tells her story of how she was sexually harassed. She goes on to say, "Question my story because we need to examine our views about sexual harassment and misconduct." And she said, "By their nature, harassment complaints are characterized by gray areas and few witnesses. Victims and perpetrators are both flawed and sympathetic." I thought it was important to read Ms. Fenwick's language because it captures, better than I probably could ever do, the challenges my office faces in our role as counsel for the employing officers on these issues. I read her words to mean that there has to be discussion and understanding around these issues. And when I say these issues, I mean allegations of discrimination. Sexual harassment is a form of unlawful discrimination, just like discrimination based on race, color, religion, national origin, age, and disability. I also read her words to mean that automatically characterizing any questions about the basis for sexual harassment allegations as victim blaming is counterproductive to rooting out sexual harassment, and I agree. Part of the role of my office is to question employee claims of discrimination, including sexual harassment, and to do so is not victim blaming. On a personal note, like most women in this country, I have experienced sexual harassment in the workplace. It occurred during the early part of my employment, and my way of dealing with it was to leave a job that I liked. As a woman of color, I have also experienced race discrimination in the workplace. I worked for a private company where a white manager brought in a whip, which he prominently displayed in his office, and when questioned about it, he said he wanted to, quote unquote, motivate the black employees. I believe these and other experiences have made me more sensitive to allegations of discrimination, not less. And I am probably a better lawyer for it because I understand the perspective of both the employee and the employer. I also try to lead by example as the head of my office. Posing difficult and challenging questions to employees, most often through their lawyers, is necessary to assess whether sexual harassment has occurred and correcting any inappropriate behavior. On the other side of that equation, when we are contacted about these issues, which unfortunately does not happen in all instances, and our clients tell us that they have done absolutely nothing wrong, we question that too. We are not in the business of covering up unlawful behavior, but rather we examine those gray areas that I mentioned earlier by conducting thorough investigations and then working with our clients to figure out how to address the concern both legally and practically. The congressional workplace is a microcosm and in many ways reflects workplaces across America. Yes, sexual harassment occurs in the Congress, just like it does in other workplaces. And while the more serious allegations of sexual harassment and borderline criminal behavior in some instances tends to receive the most attention from the media, those types of allegations are not the norm on Capitol Hill, at least not not in my office's collective experience. And of course, I recognize that this kind of behavior does go unreported, so that may account for some of that. I want to try to answer the question of what has worked to address the concern about sexual harassment. I wish there was an easy answer, but there is not. Although it is not a panacea, I believe mandatory in-person training is very helpful. I have trained quite a few members on this issue lately, and the response has been encouraging. I'm hopeful that the training has meant that members are talking directly with their employees and telling them that they should come forward with concerns without fear of retaliation. Employees won't always believe it, but this is still a positive step, and it might help to change a perception held by some that these issues should not be reported. I will say that training does work effectively, but it doesn't work effectively when members schedule it around or near votes. While I'm convinced that no amount of training will fix truly egregious conduct, that would require other mechanisms of accountability. Again, it is a step in the right direction. In closing, I want to thank the committee again, and I welcome your questions.
Thank you, Ms. Lett. Chair will now recognize Daniel Crowley for 5 minutes for purposes of an opening. Thank you.
Thank you. Chairman Harper, Ranking Member Brady, and members of the committee, thank you for the opportunity to testify today. My name is Dan Crowley. I'm a partner at the law firm of K&L Gates. I note at the outset that my comments are my own and do not represent the views of the firm, my colleagues, or any firm clients. I had the privilege of serving as counsel to the committee under Congressman Bill Thomas from March 1991 through early 1998, a period that straddled the Republican Revolution of 1994. The Congressional Accountability Act was the first law enacted by the new Republican Congress in 1995. However, it is important to note that these are not fundamentally partisan issues. Rather, they are institutional in nature. In fact, the committee's consideration of this legislation began under the previous Democratic majority. The basic principles that in the past guided the committee in this area are: 1, if a law is right for the private sector, it is right for Congress. 2, Congress will write better laws when it has to live by the same laws it imposes on the private sector and executive branch. And 3, the separation of powers embodied in the Constitution must be respected. The challenge faced by the committee more than 2 decades ago was to reconcile these principles. At that time, it was felt that the procedures established to provide a means for redress of grievances by employees must take into consideration that in the congressional context, allegations can be career-ending even if they subsequently prove to be untrue. The key constitutional provision at issue is the Speech or Debate Clause, which has repeatedly been interpreted by the U.S. Supreme Court as providing immunity for members of Congress for not only speech or debate in either house, but also for other matters that the Constitution places within the jurisdiction of either house. Moreover, lower courts have ruled that Speech or Debate Clause immunity attaches to employment decisions by members in certain circumstances. Against this constitutional backdrop, the committee sought to establish a procedure to address violations of the federal labor and employment laws by members of Congress. Toward that end, the CAA provided for the creation of the Office of Compliance within the legislative branch and charged it with responsibility for promulgating implementing regulations, conducting studies, and importantly, carrying out a program for educating employing authorities. Perhaps the most significant provisions in the CAA provide for a right of limited judicial review. However, the CAA was carefully crafted to avoid waiver of Speech or Debate Clause immunity. For example, Section 502 provides, "It shall not be a violation of any employment discrimination provision to consider the party affiliation, domicile, or political compatibility with the employing office." In other words, such factors provide an affirmative defense to allegations of discrimination. As described in the committee report, this provision and the exemptions listed therein recognize the special nature of employment in Congress by allowing member offices as well as committee and leadership offices to incorporate these 3 factors in employment decisions without prejudice to the legality of such decisions. The political compatibility exemption, while subject to broad interpretation, is intended to provide members, committee offices, and leadership offices with more flexibility than is available under the party affiliation and domicile exemptions. The jurisprudence since enactment of the CAA makes clear that in employment cases in which speech or debate clause immunity is asserted, it will be up to the courts to determine whether the privilege applies on a case-by-case basis. I note that notwithstanding the CAA, the Committee on Ethics has broad discretion to discipline members for violating standards of official conduct, which may provide another meaningful avenue to explore as the committee considers solutions in this area. In conclusion, the Congressional Accountability Act of 1995 is legislation that attempted to reconcile member intent to subject themselves to the same laws they impose on others, consistent with the legitimate constitutional protections afforded by the speech or debate clause. After more than 2 decades, it is important to review the CAA as well as the standards of official conduct to determine whether updates are necessary or appropriate. These are complicated issues that remain difficult to resolve. That said, the steps the committee took more than 2 decades ago mean that you now have experts, including my fellow panelists, who are available to ensure that employing authorities are appropriately advised. Finally, I believe today, as I did then, that a commitment to taking prompt corrective action up to and including termination must be unequivocal. Thank you again for inviting me to testify today. I would be happy to respond to any questions you may have.
Thank you, Mr. Crowley. We now have time for committee members to ask questions of the witnesses. Each member will be allotted 5 minutes to question a witness or witnesses, and I will now recognize myself for 5 minutes. And I'll start, if I may, with you, Ms. Lipnick. Certainly appreciate you being here today and the work that you've done in this area of sexual harassment and anti-harassment generally. I want to focus on your work for a moment as co-chair of the Select Task Force on the Study of Harassment in the Workplace. The EEOC has created a document titled Promising Practices for Preventing Harassment, identifying 5 core principles around which proven practices are identified. Can you give us a little insight as to what practices would constitute an effective sexual harassment education program, and in your opinion, of that, what have you seen that works or doesn't work?
Certainly. And I would tell you, Mr. Chairman, that the promising practices that are on our website are completely derived from our task force report and the recommendations that we made in the task force report. So there are 5 core principles that we think are important for preventing harassment. And again, our task force was focused on prevention. At our very first meeting of our task force, we all agreed that we all know what is legally actionable harassment, but that is not working as a prevention tool. So we focused on 5 things. One is there has to be committed and engaged leadership. There has to be consistent and demonstrated accountability within an organization. There has to be strong and comprehensive harassment policies in place, trusted and accessible complaint procedures, and I would emphasize trusted procedures, and regular and interactive training that's tailored to the audience and to the organization. And as I said earlier, we were very critical of training, much of the training that's taken place and developed over the last 30 years as a prevention tool. But we do not by any means reject training as a tool. We believe that training is absolutely necessary, and what Ms. Lett referred to in particular, and she said in-person training can make a big difference. So we have a number of recommendations about training, that it has to be customized to that particular workplace. The leadership of the organization has to show up for it and demonstrate that they are interested in it. It has to give examples to that particular workplace. And it is very important in training that individuals in the workplace focus on training not even so much as what is harassment and what isn't, what are the procedures by which people can report, they know who to go to, they know what the consequences will be, what will happen. That is an important component of the training as well.
So this is not going to be effective or as effective unless the person at the top
Absolutely
says this is going to be the way that it will be.
Yes, and I have spoken on this in many places, and you will oftentimes hear, in particular, outside counsel who are called in to do trainings at corporations, and the head of the business unit or the organization will show up for the very beginning of the training and say, "I want you all to pay attention to this," and then leave.
Okay.
Right, and so the leadership of the organization has to be as committed to it and as engaged in that training and send the message to the individuals who are receiving that training.
Thank you very much. If I could now, Ms. Lett, I'd like to ask you a couple of questions in the time that I have left. Would you describe OHEC's role in the counseling or mediation phases? And specifically, is OHEC retained by an employing office when counseling is initiated or when mediation begins, or does OHEC already have an attorney-client relationship with the House office prior to being notified of a CAA claim?
I'm going to give you a lawyerly response, and that is, it depends. In many instances, we will know when a complaint is coming down the pike, and that is because the employing office has contacted us. There's been an employee who is dissatisfied with something that's going on in the workplace. They have attached it to a discriminatory motive, and we've worked with the office to try to address the situation. Sometimes an employee will have an employment performance issue. They've been put on a performance improvement plan that hasn't worked out. The employee is terminated. And so we've worked with the office through that entire process and anticipate that when the employee loses his or her job, that they're going to go to the Office of Compliance. Okay. We anticipate that. We don't know when someone has gone to the Office of Compliance initially for the counseling phase, because that is confidential. Sure. Unless the employee waives it. Okay. When mediation is requested, then we would be notified automatically. Again, we might know about that ahead of time, that it's coming down the pike, or for the first time when we get the notice of mediation. Sure. And of course, at the mediation phase, we represent the employing office and attempt to resolve the matter at that point.
Okay, thank you very much. My time's expired. The chair will now recognize Mr. Brady for 5 minutes.
Thank you, Mr. Chairman. For Gloria Lett, of all the cases you handle, how much of your work is focused on sexual harassment?
I anticipated that question, and I have a list here in terms of the number of cases and the categories in which they occur. We typically see mostly retaliation cases, because when employees file claims, they always put in, they routinely will include a retaliation claim. Followed by retaliation is the Americans with Disabilities Act claims, race claims, Fair Labor Standards Act claims, Age, Family and Medical Leave Act, and sex discrimination, gender discrimination cases come in at about the same rate. It is followed by sexual harassment claims, pregnancy claims, national origin, and military discrimination claims come in at about the same rate, and then finally claims based on color.
Do you support eliminating the cooling off period?
I don't have a strong position on that one way or the other. My only caution about eliminating that 30-day period is that oftentimes we do settle cases during that period. So it would take away another opportunity to possibly resolve a case before a party goes directly into litigation.
In your advocacy for employment officers, do you find that just your engagement, the engagement that you are engaged with, changes office behavior in the future?
I think it's difficult for us to know to a certainty whether that is happening, but it has been reported back to us that when there has been an incident of some kind or some allegation of discrimination, and an office speaks with us and tries to take appropriate action, we do action items, after action items with the office. That might involve training for a particular individual. It might involve training for the entire staff. It might mean, in some instances, and not all House employing offices have written policies, so it might mean sitting with them, adopting those policies, rolling those policies out with the employees and having conversations going forward. So I do think that there is a lot of positive that comes out of some of these situations.
Thank you. And for Mr. Crowley, thank you for your service on the committee, and understand you work with my former counsel, Charlie Howe.
Yes, sir.
Who was a real gift to the members of this committee in drafting the CAA. Why did Congress exclude the Library of Congress from some of these protections? Was that a mistake, and should we fix that and include now the Library of Congress?
You know, Congressman, I have to tell you that my recollection of these issues is now 22 years old, and so I don't remember every discussion we have.
I can appreciate that, sir.
Yeah. I do recall a number of conversations involving the library, including whether the police forces ought to be unified. I don't remember the specific discussion about the library, although I think the answer might be, and I defer to my colleagues, that they were already covered to a certain extent under federal law, if I'm not mistaken.
Yes.
Perhaps I can provide a little insight. The Library of Congress does have its own internal personnel system, but that system is entirely internal. There is a hearing process in the Library of Congress, but the hearing officer's decision is merely a recommended decision. It must be forwarded to the librarian, where she can either accept or reject that decision.
Do you think we should include the Library of Congress in this ongoing hearing and discussion and maybe for a bill?
We do.
Thank you. Ms. Lipnick, in June 16th report, you write about the risk factors in our workforce. Among them are many young workers and officers with significant power disparities. Congress is obviously a dramatic example of both of those risk factors. We passed a resolution focused on training recently, but no one believes that training is enough. And this hearing is about improving our laws, and that is important, but it is also not enough. We really need to change the culture. So based upon your experience beyond providing training and changing laws, what other work can we do to change that culture?
Thank you, Mr. Brady. So one important point that I think the committee should consider as you are looking particularly at revising the Congressional Accountability Act, and this is, and I would look to the testimony from Congresswoman Spear from your November hearing. There is a difference between what immediate action has to be taken when someone is concerned and complains that they are being sexually harassed versus what is all of the process that the Office of Compliance deals with and the House Employment Council when you are looking to, is there liability? And so, as Representative Spear said, you have to be concerned about what's happening to that person who's complained about it when she is still sitting there in that workplace. So I would urge you to sort of bifurcate your thinking on this and understand that that immediate action and that investigation that has to take place, which I think that the House Employment Council, I understand from the testimony, does a lot of that. You should consider how detailed can you be and how can you instruct your work environment as to how you want to deal with those immediate issues of harassment. Think of harassment claims different from other types of discrimination claims. So it is one thing to allege you did not get promoted to a particular job in, an office because based on your sex. That is very different than a harassment complaint and a harassment claim. And so the immediate investigation that has to take place, which may be referred to the House Employment Council's office or maybe the Office of Compliance does that, I would urge you to think about what is that process and what is that type of corrective action that is taken immediately. That, again, is very different from all of the other process that is in place that determines what's the, is there liability here. So that is one thing that I would urge you to think about. Overall, in terms of, and your focus on culture is very much what our select task force spent a great deal of time on, and there are a number of things that will influence a culture. again, including what's the message that's being sent from the top, and is the leadership of the organization owning each individual workplace? And of course, workplaces, in Congress you have a lot of, as you mentioned, the number of risk factors. You have a lot of young people. You have people working in very close quarters. You have people working very long hours. I think there's a recommendation maybe in one of the bills that you do a climate survey. Those are things that you can also consider, and make sure that you are reviewing those things on a regular basis. But culture and the message that is sent from the leadership and the engagement within each individual office to address that are very important factors and can do the most to act as a prevention tool.
Thank you. I thank all the witnesses for being here and for your testimony. Very important and educated testimony. Mr. Chairman, I yield back.
Thank you, Mr. Brady. Gentleman yields back. Chair will now recognize the Vice Chairman of the committee, Mr. Davis, for 5 minutes.
Thank you, Mr. Chairman, and thank you to all of our panelists. Ms. Lett, it's great to see you here again. Thank you all for your testimony. To begin, I believe an important takeaway from our previous hearing is the need for the OOC and OHEC to become more familiar with the policies and procedures, not only of the workings of both of your organizations, but really how the ethics committee process works as well. I also encourage more outreach to the Hill in general, and so you have a sense of how best we can all work together to serve and improve this great institution. I want to focus my questions today, though, on Ms. Grunman. And I really want to focus on OOC's outreach to the Hill. Your testimony discusses the need for new employees to receive training. How is the OOC currently reaching new employees with this information?
We have a very unique mandate. In fact, we're compelled to train on our statute by the law. And it's a very robust program, which is for a very small office that's administered largely by 2 people. As I stated in my opening statement, 500 people have been trained in person in the last 6 weeks. Our online training module has soared in recent times, and here's an example. In September, 5 people completed the online training module for sexual harassment prevention training. In October, it was 618. In November, it was over 4,000, with 800 people arriving just last week. So in addition to this type of training, we are developing new training. Coming on December 10th is a new comprehensive online module that talks about anti-harassment, anti-discrimination, anti-retaliation. In production right now is an overview orientation of the Congressional Accountability Act. We have a new module coming up as well that will focus on how to report sexual harassment, how to respond to sexual harassment, and behaviors that could lead to sexual harassment. In addition, let's talk about new employees. We don't know who these new employees are. We would love to be notified as to when new people are onboarded so that we can communicate with them directly.
So let me get this straight. There's no contact between our office of our payroll office here at the House of Representatives and your office when a new employee comes on board?
That's correct.
Okay. You mentioned in your testimony, too, you wanted to reach more younger staffers.
Yes.
What are you seeing the younger staffers taking these training modules that you just mentioned in the last few months, or do you show by age? And how are you going to reach more younger staffers?
Well, let me answer that question. We don't know exactly the age or the person that's taking the module. We just know the hits that we're receiving. What we could explore doing, and we could do it with this committee and the members of this panel, is a particular module designed specifically for new employees and younger employees. They do face different issues.
Okay. I think it's a great point that there probably needs to be more communication between our offices that are run by the CAO and the OOC to make sure that those modules are out there and the training is in. I also think it's important that we develop training for senior managers Because they're going to be the first ones that an employee will go to address the process. And I think our senior managers need to know a little bit more about the process. How can we address that?
Well, there's actually a module in place right now on anti-discrimination, anti-harassment, anti-retaliation. That actually meets the standards for managers in the Senate, the resolution that passed recently. So it is there already.
Well, excellent. And in your testimony, you talked about how you hope to strengthen OOC and your outreach programs. We look forward to working with you to do that. I do want to point out that the author of the Congressional Accountability Act, our former colleague Chris Shays, is in the audience today. And thank you for your work on this, Congressman Shays. I do want to point out, while I have a little bit of time left, Ms. Grunman, and I notice that we have many of your annual reports that will come out every couple of years. There wasn't a lot of focus in the 2016 report on sexual harassment in the workplace. And I would hope as we move forward that the OOC and those who make up the agency would help us, help you identify how we can better serve all of our employees at all levels, and also understand how we can get anybody who may be a victim in front of you, in front of the office, and on the path to get the problem rectified. That's the goal, and I appreciate you being here.
Great. We couldn't agree with you more.
Thank you. I yield back.
Gentleman yields back. The chair will now recognize the gentleman from Maryland, Mr. Raskin, for 5 minutes.
Thank you very much, Chairman Harper. So I think I want to begin with a question with Ms. Lipnick. The less power and equality that women have in the workplace, the more vulnerable they are to sexual harassment. I think we've got to take it as both a sign and a cause of progress here that we have 84 women, I think it is, in the U.S. House today, and 21 in the Senate. One can only imagine the conditions of sexual harassment when the Senate and the House were all male. Or virtually all male. But I saw an interesting comment by Barbara Ehrenreich, who's noted kind of a class bias in the sexual harassment discussions that we've been focused on, lots of women who are in professional jobs, and she said people are not talking about the hotel workers, the farm workers, the waitresses who face rampant sexual harassment and so on. And I'm just wondering, is there anything that we can do that will benefit everyone, if not in the same legislation necessarily, but are there policies we can advocate that will actually make a change for people across society?
Thank you for that question. So in our work at the EEOC, you're absolutely right. I mean, we see harassment claims across industries, across income levels, from the executive suite to the factory floor to the farmers' fields. We've had horrendous cases of harassment for particularly vulnerable workers. That's part of the reason why when we put our task force together, we included representatives from worker advocacy groups. So certainly things that are more outreach along those lines and that recognize the work that advocacy groups, worker advocacy groups can play, and how individuals who are in vulnerable work situations can go to those organizations and seek some redress. You know, certainly one thing to consider, and this is something that we have in the federal sector, is requirements that there are different, information is provided in different languages. So that, you know, you're reaching populations that, particularly for vulnerable workers who English may not be their first language. So that's certainly one thing to consider. In terms of legislative changes, in terms of Title VII, I'm not sure that there's anything that I could recommend right now, and I'd certainly be happy to give more thought to it.
Okay, wait, let's pursue that if
sure.
you could, and I thank you very much. Ms. Let me ask you, you began by mentioning the interesting article, which I saw too, Question My Story, by a victim of sexual harassment, and you invoked her description of gray areas and the lack of third-party witnesses and so on, and it brought to mind F. Scott Fitzgerald saying that the sign of first-class intelligence is the ability to hold contrary thoughts in your mind at the same time and still conduct yourself effectively. And everyone agrees we need zero tolerance, and everyone agrees we also need a process that's fair to the victims and fair to the accused. The problem is that people today think that our process is so cumbersome and convoluted that its purpose is not to discover the truth, but somehow to bury the truth or to complicate the truth. That's at least the public perception. And so what can we do to make sure that we do have a process that is fair, that's perceived as fair, but also moves things quickly enough so that people see that we're taking the issue seriously?
Well, as I mentioned before, when I was asked the question about the cooling off period, I don't have a practical reason to think that that's not a good idea. Certainly, it's not going to change how we do business. And so eliminating possibly that particular piece of the process might be helpful. I do think that there, and I know that the Office of Compliance can speak more to this, but
just to be clear, you're saying that we don't need the cooling off period?
I don't, from my perspective, I don't think it's needed. As I said, the one reservation I have is that it does provide an additional chance to resolve a matter before full-blown litigation begins. I do think it's important to communicate to employees their rights. That's not my job, not our office's job. And I know that there have been, over the years, efforts by the Office of Compliance. I remember when I first started on the Hill, we would get paychecks, and there would be communication about the Office of Compliance and our rights under the Congressional Accountability Act. So more efforts, of course, to train employees, to make them aware of their rights, and ongoing communication, I think, would be helpful. I have to say the plaintiff's bar is very savvy about these rules, and typically employees don't have problems getting attorneys representing them. Most of the concerns I've heard is that the process is lengthy, so eliminating the cooling off period would be helpful.
Thank you, Mr. Chair.
Gentleman yields back. The chair will now recognize the gentlelady from Virginia, Ms. Comstock, for 5 minutes.
Thank you, Mr. Chairman. I wanted to focus on what you cited, Ms. Lipnick, as one of the best prevention methods, which is the trusted complaint procedures. Now, we have the procedures that by law you're required to have, so I appreciate, Ms. Lett, as you laid out, you have to deal with both sides. But we've been talking about, and I think a number of us have talked about, having some type of victim's advocate, having a separate person for the victim, whether it's an ombudsman, an advocate, a victim's counsel. Wouldn't that help if we had somebody where the victim can go, and even if they've had the training, when you're in that situation, I mean, we have special people for rape victims, they then go, and you're walked through the whole process at that point when you're in crisis. So if we could have somebody that they could go to in that type of situation, wouldn't that improve the whole dynamic of the experience for the victim, putting them on a level playing field, and helping them through this process? Maybe I'll start with you, Ms. Lipnick.
Sure. I think that's a very valuable suggestion. One of the things I would tell you that when we were doing the work of the task force, we actually invited people from the Pentagon, from the Defense Department, because of what they've been dealing with for the last, 14 years, and their own internal procedures as to sexual assault in the military. And so having a victim's advocate is something I know that they set up there, and I would urge you to maybe consult with the generals there who've been dealing with that, and they would have more experience with that. But that's something that I think your focus on that, addressing the immediate situation, and for the person, what can help them in that immediate situation? How will they know, what's going to happen? And what's the corrective action that is taken immediately needs to be a big focus.
Okay, thank you. And I know that was in Congresswoman Spears' legislation, and Congressman Byrne had talked about that. And I do want to thank Ms. Bertucci again, because when I had asked her with her situation, what could we do that would have helped? That was an ombudsman, a counsel, an advocate was the single, thing that she identified that I do think is, just thinking about that experience, I think it's very important that we get that in the legislation. And then also have that be, also imbued through the training also. Perhaps on the training process too, when someone sets up just a house account and they're a new employee, maybe we can have more socialization and getting the information directly to them in multiple methods, not just here's a class you can go to, but let's make sure we're getting more information out that way. And then I wanted to, I guess the Office of Compliance, I know you are continuing to go through the records and to give us the information on the overall cases, and I think, Ms. Lett, you went through the type of cases you're getting. But given the public's concern and sort of the public right to know about what type of cases you're dealing with, and particularly, when members are involved and/or members' staff, do you estimate you will have that information soon so that we can have that available for the public in whatever legal way you're allowed to have, but have a much more detailed accounting?
Couple things. Let me just address the Victims Council just specifically because it was part of our statement. We understand that during at least the counseling stage and certainly in the mediation stage, when the employing office is represented by OHEC, that the victim feels entirely alone and is at a severe disadvantage. So what we propose to do is really beef up the counseling stage so the counselor actually actively participates in technical advice in drafting a complaint. That, coupled with investigatory authority given to our general counsel to immediately investigate these claims as it emerges, can be a form of advocacy on behalf of the employee. But in response to your question, and this actually dovetails into Mrs. Brooks' request to us regarding the ethics, we provided a response this morning. The law as it's currently written is difficult for us to produce this kind of information because we know that in counseling it's strict confidentiality, and that binds our office from discussing it. The employing office, as Gloria Lett said, is not told. In mediation, there's also strict confidentiality, and that specifically adheres to the products, the materials that are produced in mediation. And that's, again, strictly confidential, but it's not unusual in our process. Mediation is private throughout the industry. What our law specifically requires in terms of producing information in the rules is numbers and types of inquiries that come to our office, number of types of initial requests for counseling, numbers of covered employees to the complaints they file, the claims they raise, and the disposition of those claims. In terms of disclosure to ethics, we, to our knowledge, have not received any requests from your, up until this recent one, so we appreciate the concern. The law as it's currently written only allows us to disclose this type of information in a very narrow circumstance. When the case, under two conditions, when the case reaches a final decision and the employee is consulted. So in the event that there's, we cannot release documents with respect to counseling, mediation, where there is no final decision and when the employee has not been consulted. Having said that, we would like to work with this committee to change that rule. And a potential change really goes towards granting us the authority to investigate claims. If the general counsel were granted that authority, it would be similar to what we have in ADA and OSHA. The general counsel at that point could find that if there is reason to believe the law had been violated, a report could be generated, and that report could be made available to you.
Okay, and Mr. Chairman, I would just mention, I hope we can get much more detailed information and whatever, if we need to make changes to allow you to do that, because if we are going to correct the process, we need to know what has happened, where the complaints have been. I noticed we did get, the committee got a report on November 28th, a memo detailing from 1997 to 2007, where it laid out that 90% of the cases were with the architect and the Capitol Police, probably a lot of safety things, but I think we need to know what are the type of cases, and then when members or member offices are involved, and how we're going to do that going forward. But I think the public has a right to know that going back, and certainly going forward, how we can improve that transparency. So I hope you can work with us on that and getting more detail.
Understood.
Gentlelady yields back. Chair will now recognize Gentlelady from California, Ms. Lofgren, for 5 minutes.
Thank you, and my apologies for being tardy. The FBI director is over in the Judiciary Committee, and I had to be there for a bit, and I think my colleague, Mr. Raskin, has the same conflict. This obviously is a very serious matter for us, and we are, I think, very clearly going to change the procedures and the statute that we have. So the question is how to do that, how to avoid pitfalls. And one of the things that I'm interested in is the recommendation that you've made, Ms. Grudman, on the additional powers for the General Counsel that you just referenced, specifically how the Counsel would use those investigative powers to get to the facts of the matter that you currently can't do, what conflicts might exist if that were assigned to you, and could you more fully explain that to us?
Absolutely. Rather than reinventing the wheel, we propose to use the internal mechanisms that we currently have. And the General Counsel, as we state, does have investigatory authority in certain areas, such as in OSHA and ADA. And how that really works is a claim can be filed anonymously, which is unusual. It's not the same in the labor forum, but the current practice would be the General Counsel would work with the employing office. Now, clearly, that's not going to work in this particular circumstances. But in the investigation, there is a move towards resolution, because in OSHA cases and ADA cases, there's a lot of dollars involved. So there's a significant amount of negotiation and discussion. If the matter is not resolved, it could result in the filing of a complaint by the General Counsel. The General Counsel will actually represent the employee in this case and moving the case forward. That is the process we envision putting into effect. The reports are not made public, and they're given to the party that can control the outcome, who can fix the outcome, if you will. So the process is in place. The concern we have is the lack of staffing. We don't know how great the volume will be.
Right. Of course. One of the things that I think we want more transparency on some of this, and the issue, I mean, if you have an employer-employee dispute, for example, under the act that we adopted in 1995, certain employees are exempt from overtime, and certain employees aren't, just as in the private sector. You could have a dispute about that category and a fight about overtime. I don't know that that needs to have the same level of disclosure as a sexual harassment thing. We want to stomp that out. And part of the way to do that is to have some daylight on this process. So one of the things I've been thinking a lot about, and certainly my colleague, Ms. Spear, has done the work on this bill, but it's a beginning point. How do we make this transparent in a way that protects the victims who want to maintain their privacy, but some victims are bullied into a confidential agreement. So I'm just wondering, in terms of what other people in an office where there's sexual harassment, what their role is, what their obligation is, and are they constrained by these agreements that are being undertaken right now?
So part of our training does, in the future, coming soon, will cover bystander training. Specifically, how do people who view this type of activity, what do they do? And I think that's something Representative Spear has previously mentioned in terms of our training. It's a hard area for us to deal in. The confidentiality that's currently in the rules prohibits us from having a conversation.
Yeah, but we can change those rules.
True.
I mean,
and let me urge this committee, as you go about changing these rules, one of the communities that you need to reach out to really is the plaintiffs' bar and the employee representative.
Right, and we are
bar.
doing
They
that.
have a certain Let me also talk a little bit about what we hear, non-disclosure agreements. That is a very confusing area, but we have a very simple answer. We don't require non-disclosure agreements. It is a product of the parties. We don't provide standardized language, and we don't require anybody to sign a non-disclosure agreement to come into our system.
All right, that's important, but certainly the inherent power differential between, say, a member of Congress who's harassing and a staffer who's been harassed is pretty extreme.
Absolutely.
And I think I read an article recently about a young woman who stepped forward and has never been able to be employed again, even though she did the right thing. So certainly we need to get our heads about how to protect victims even beyond a settlement agreement. And I see my time has expired, Mr. Chairman. Thank you very much for your testimony.
Gentlelady yields back. The chair will now recognize the gentleman from North Carolina, Mr. Walker, for 5 minutes.
Thank you, Mr. Chairman. Again, I'd like to thank Representative Bradley Byrne and Susan Brooks for the leadership, not just on this committee, but the example that you're set in our entire conference. I have a couple questions for Mr. Crowley. It's come to our attention that federal agencies are required to reimburse this judgment fund for judgments against agencies and settlements for discrimination in the workplace. Yet there is no comparable requirement for Congress. So when we talk about liability, what discussions were held prior to, during consideration of the Congressional Accountability Act regarding personal liability for settlements and final judgments awarded under the CAA?
Well, Congressman, again, my memory is 2 decades old here.
Understand.
But as I recall, there was a very clear discussion early on that would have simply prohibited personal liability for members as well as punitive damages. That changed as the process unfolded to limiting the ability to pay judgments out of the new fund that was created. And of course, those discussions occurred extensively with the Subcommittee on Legislative Branch Appropriations, who had a significant input into that decision. But I think the general notion was that, first of all, it's not the member personally, it's the employing office of the member, so that, for example, if a member leaves office, there would still be the ability to get restitution from the office after the fact. So I think it would be aberrational to hold members personally responsible when, in fact, it's an employing office of the Congress for all other purposes, including the Federal Tort Claims Act, et cetera.
Okay, all right, you covered actually the second part of that question, so let me then ask this. Is there any provision in the Congressional Accountability Act or in House rules that would forbid the use of the MRA funds to pay for a settlement reached at any point during the dispute resolution period?
I'm not sure there's a clear answer to that question. There is in the statute a limitation on what funds can be used to settle claims. But of course, members have broad discretion over the use of the MRA, and I imagine that in certain circumstances, particularly when part of the settlement involves reinstatement to a position, that implicitly the MRA would be used.
Yeah, and I can't imagine that that wasn't part of the discussion with the authority that a member would have, and even going back to those years, the budgets for staffing were much higher than they even exist today. 2-week settlement or a month for conflict resolution, or maybe an employee didn't fit, but the authority or the ability to cover up such office behavior, wrongdoing, harassment, leaves a lot of discretion in the member's hands. So is that what you're telling me, that there can be a separate settlement or payment outside of the Congressional Accountability Act using the MRA?
I think members implicitly have that authority, but you have to remember that at the time, the MRA didn't exist until Bill Thomas created it. Before that, we had the clerk hire allowance and roughly a dozen different allowances that were consolidated with the specific intention of giving members discretion on how to deploy those resources, to such an extent that the committee was actually renamed from the Committee on House Administration to the Committee on House Oversight, to emphasize the fact that it was not going to be determined at the committee level but by the individual member. And so I think that there's some conflict between the Congressional Accountability Act language and the inherent authority that members have over the MRA.
Your testimony highlights the speech and debate clause within the Constitution. Can you explain to the committee how this clause has been interpreted by the Supreme Court and its applications within the context of the Congressional Accountability Act?
Yes, sir. The lower courts, I don't think the Supreme Court has ruled, but the lower courts, the D.C. Circuit in particular, has ruled that the speech or debate clause does not preclude suits under the Congressional Accountability Act, but there still remains the immunity that is essentially an affirmative defense that members can assert. And so we've created sort of a gray area, you know, stepping back to the original discussions around the Act. There was case law saying that it's unclear whether Congress can waive its constitutional privileges, but any waiver would have to be explicit and unequivocal. Yep. And I would have to say that in the Congressional Accountability Act, we equivocated. Right.
And one last question. It's a simple yes or no, Mr. Crowley. Do you believe it's wrong for members to use the MRA to settle interpersonal sexual harassment claims?
My personal opinion
that
the taxpayer should not be on the hook for that.
Thank you. With that, I yield back, Mr. Chairman.
Gentleman yields back. The chair will now recognize gentleman from Nebraska, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman. Thank you to our witnesses, and certainly thank you for this interaction today among members, and certainly a very serious topic. It's interesting. I appreciate my colleague, Ms. Comstock's recommendation for a victim's advocate. And if each of you, starting with Ms. Grundman and Ms. Lett, if you could express how that might be able to be brought in to the existing process, what changes might need to take place so that if that's the decision to make changes, if that would work and how that might work. And then Ms. Lipnick, if you could perhaps express your knowledge of how that's been done elsewhere and how effective it has been. Go ahead, Ms. Grundman.
Sure. What we propose really is beefing up what we already have, rather than throwing out what we have and creating a separate office. We could take the counselor's position and actually make it a much more interactive process with the employee, whereby the counselor would help technically advise the employee on how to draft a charge or a complaint, coupled with using the general counsel and giving him the authority to investigate claims in the dispute resolution program. If the general counsel were to find that there is a reasonable cause to believe that the law were violated, he would actually represent the employee in further administrative processes.
Thank you. Ms. Lett?
I would have to think a little bit more about how it would work in terms of the specifics, but I can tell you that it would likely be a welcome thing from my client's perspective, in that I think an advocate would encourage employees to come forward sooner rather than later. That would be music to our ears, certainly, because the sooner an employer knows that there's an issue, the sooner they can address it. It's not a good model when things barrel way down the track and an employee feels that he or she has to go to the Office of Compliance for relief. So I think that absolutely could be some upside to that.
Okay, thank you. Ms. Lipnick?
Mr. Smith, all I would add, by the time people are coming to the EEOC to file a charge of discrimination, they are at that point, we are investigating for liability purposes. So there's no victims advocacy role on the part of the EEOC itself.
Okay, thank you. Mr. Crowley, do you wish to comment?
Well, I think it's an interesting idea. It's amazing to me the extent to which the issues haven't fundamentally changed. The intent at the time was to create a process that would both encourage victims to come forward and allow for resolution in a way that didn't incentivize politically charged claims immediately before an election. And so anything consistent with those objectives, which this sounds like this might be, or seem worth pursuing.
Okay, thank you. I yield back.
Gentleman yields back. The chair will now recognize gentleman from Georgia, Mr. Loudermilk, for 5 minutes for questions.
Well, thank you, Mr. Chairman, and thank you all for being here. Of all the issues that I ever thought I would be dealing with when I ran for Congress, this is not one of them. And in fact, it sickens me that the idea that the most respected legislative body in the world, the reputation is being tainted by us discussing this, but it's extremely important, and it boils down to character. And in reality, there's nothing that we can do to affect someone's character, but we can remove the bushes that allow them, the bad characters, to hide behind, and I think that's kind of the direction that we're looking. Ms. Grundman, in your testimony, you described in detail OOC's process and makes several recommendations, but one of the areas that you didn't really address is OOC's role in administering the awards settlement fund. Can you kind of take us through your role in the payment process once the tentative settlement is reached or a final judgment is received?
Absolutely. But first, if you will allow me to clarify, the statute refers to funds that are appropriated by the Treasury. In actuality, there is no fund. It is an account, and that account is empty until we requisition the funds for a particular award or settlement. And also to be clear about the settlement, this settlement account, the $17 million we've talked about, yes, it covers awards and settlements from our dispute resolution process. It also covers awards and settlements from district court. It also covers settlements and awards that derive out of the arbitration process for various collective bargaining agreements in the legislative community, such as at the Architect of the Capitol and at the Capitol Police.
Okay. Can I ask one quick question,
Sure.
and we'll get back to this? It's a $0 account. When something occurs like we're talking about here, where's the money come from?
We actually requisition it. The account is empty until a settlement comes through, and then we ask for the money through the vehicle of a warrant, which should be familiar to this committee.
Right.
Our role in settlements is purely ministerial. We don't, the parties negotiate the terms. It's incumbent upon them to agree. It is incumbent upon OHEC to secure the proper authority from this committee when settlements come out of the Treasury for the House. But should Congress desire to beef up our role, for instance, by giving us a greater review for legality of these decisions, you would have to change the act. Currently, we don't have the authority. The only thing we look for is whether it's signed by the parties and it's a written statement.
Can you kind of walk me through this process? Let's say this $0 account, you receive notice of a settlement of X number of dollars. Then you request through warrant that much money. Exactly. Can you start at that point, walk us through who sends the money to the account? Is it the Treasury? Is it from House Appropriate? I mean, and until the individual who filed the complaint receives the check, what is that process?
Let's take one step back.
Okay.
When the settlement is reached, the award comes to our office. We review it for two things, in writing and signed by the parties. That is it, and clarity, essentially. Okay. That settlement agreement then goes to our case administrator. She obtains payment information from the parties who will receive payment, routing information, banking information. Then the document moves down the hall and it goes to our budget officer. She actually requisitions the funds. This is the account we're talking about through the vehicle of the warrant. And once the funds are there, the settlement agreement actually goes to a fourth.
Who do the funds come from?
They come from Treasury.
From Treasury. Okay, thank you.
Yes,
Sorry.
There. And then the final step that we have in this process is the agreement goes to a fourth person to check that all the information is correct, the routing information, and then the funds are released. At that point, our involvement with the fund ends. We do not determine when the person is paid. There could be an offset, for instance, but we're done with the process.
Okay, is there any other process in there to where anyone in Congress is notified of a settlement, has to sign off on it, or is it just within your office?
It's other than Rule 10, which governs this committee, whereby the chairman and the ranking member have to sign off on particular settlements that come out of this account. That's the only rule.
So in that process, then, the chairman and ranking member do sign off on that?
That would be a good question for Ms. Lett.
Okay, and Ms. Lett, a few moments left. Could you answer that question?
The answer is yes.
Okay.
If there is a settlement that comes out of the Treasury, that has to be approved by this committee.
Okay, thank you. Mr. Chairman, if we do other questions, I have some others, but I'll yield back at this point.
Gentleman yields back. The chair will now recognize Ms. Spear for 5 minutes for questions.
Thank you, Mr. Chairman. Mr. Chairman, it's been said a couple of times, and I just want to underscore the importance of having the plaintiff's bar appear before the committee as well, to hear from them how the process has or has not been working so we can refine it moving forward. To the last question that Mr. Laudermilk just raised, it was my understanding in one article that I read that the former chair of this committee declined to approve any sexual harassment cases. And as a result, the MRA started to be used for that process. Is that your recollection, Ms. Lett?
That's not exactly accurate. There were more than sexual harassment cases that were not approved.
Well, maybe so, but were there sexual harassment cases in which the former chair declined to sign off on, the ranking member was not made aware of? That's how it was reported. I'm just trying to get clarification.
I don't remember the exact number. It may have been 1 or 2, but it certainly was not more than that.
So if it is not signed off by the chair, then there has to be another way in which the settlement is reached. And that, in my understanding, is how the MRA has been used in some cases.
That's correct.
I want to focus back on the victim. One of the problems, and you made mention of it, Ms. Lipnick, is that you have a victim who's come forward, is concerned about the fact that she has been sexually harassed, either by the member or someone in the office, but she has to continue to work in that office in order for it to be resolved through the Office of Compliance. If she doesn't continue to work in the office, then the Office of Compliance has no role, correct?
I thought you were talking to Ms. Lipnick. There is a concern that we haven't discussed here today, and that really is about retaliation. You know, the employee has filed a claim.
That's what I'm getting to.
That's perfect. Retaliation is covered currently under the CAA in that an employee who has come to our office, experienced some sort of retaliation, would have a separate claim. But here's how the process works. The employee comes in, they seek counseling, they go to mediation, the employee office now knows of the claim, there is retaliation that occurs. Under the current process, that employee would have to restart the process again, go back through counseling, go back through mediation. And this is why we proposed the possibility of investigations for our general counsel and the possibility of amending the complaint so that the charges all merge at one point in time rather than going back through the whole system again.
So I'm also concerned, though, that we don't have a means yet, and possibly should consider this, to allow the employee to work remotely to the extent that they can. In some offices, you can't. If you work for the architect and you've got to be painting offices, you can't do that remotely. But in offices where you can, so that there is not the continued environment that is very uncomfortable for the victim.
May I address that, Congresswoman? That there actually is a way that that can happen, and it has happened in other cases.
I think we just need to make it explicit, is what I'm suggesting. I don't think it's always been the case for everybody. There was one of the complaints that was filed that went through the process, the employee had to be in the office, and I don't think that's right, personally.
I can't speak to specific cases, but as I said, employing offices have a lot of flexibility in this area. And I think that this is an area where employers have been very effective, because as soon as we know that an employee has engaged in protected activity, we will counsel the employing office very strongly that while the underlying case may not have merit, if the employee is retaliated against in any shape, form, or fashion, I mean, if they even have a thought bubble to retaliate, they're going to face a very difficult case. And so I think we've never lost a case on retaliation because
all right, my time is running out, so I'm going to ask to be able to ask a couple more questions.
Sure.
Soft landings. That one case that we all are familiar with where the employee after the settlement, couldn't find a job in the Capitol. I'd be interested, maybe we don't have time right now, but some kind of discussion about what we do for employees who have, through no fault of their own, have been sexually harassed. They've come forward. They now have a scarlet letter that they wear and cannot be employed elsewhere.
Could I answer that question just very quickly? Under the current law, an employee who has left is still a covered employee up to 180 days from the violation. So if there was retaliation, if they had left, they could still file a claim for that 180 days.
Yeah, but what happens if they still want to work in the building?
Larger policy. Yep.
Thank you. I yield back.
Gentlelady yields back. The chair will now recognize the chair of the Ethics Committee, Ms. Brooks, for 5 minutes.
Thank you, Mr. Chairman, and thank you again for allowing me to participate. I'd like to ask permission to admit for the record the letter that Representative Deutsch, my ranking member on ethics, and I submitted that Ms. Grunman has just referred to, the letter of December 1st. Thank you, and I'd also ask unanimous consent that we admit into the record the Office of Compliance's response that was received this morning that I have been reading this morning.
Without objection.
Thank you. In our letter on December 1st, we asked that the committee, and because this is a hearing about the process and about examining reforms to Congressional Accountability Act, that's what I want to zero in on. There are many, many other things I would love to talk about. However, we asked OOC to promptly provide the committee with all records in the possession of the office related to any claims of sexual harassment, discrimination, retaliation, and so forth. The response that we received today indicates that you refer, and I quickly went to Section 1416 of confidentiality. As I am reading your response, you cannot share, because of the strict confidentiality rules, any claims that you have been involved in, OOC, relative to referrals to ethics. Am I correct?
You're absolutely correct. The way the law is written is the confidentiality, the strict confidentiality, not only binds the parties, it specifically binds our office from discussing those claims. And you're talking about claims overall. The law currently prohibits us from releasing information regarding in the counseling period, in the mediation period, but allows for a very narrow exception when a case has gone to hearing and the record final decision has been rendered and the employee consent.
And to that point on the hearing, there was only one hearing in 2016, in fiscal year 2016. Is that correct?
If that's what's in the letter.
That's not in the letter.
No,
that's on a screenshot on your website.
And now it's possible that that case settled.
Okay. There was one that
no
indicated hearing, and you indicated, but you indicated in this letter that there have been no proceedings before a hearing officer, and the hearing officer comes after mediation. It's the end stage of your process.
Correct.
Correct? Mm-hmm. And you indicate that there have not been any proceedings before a hearing officer or a board relative to any members or employees.
Correct. That doesn't cover district court.
Okay. That covers the Court of Appeals.
Does not cover the Court of Appeals. It only covers our administrative hearing process before one of our hearing officers.
Okay. And so are you saying that there are matters that have gone to district court?
There are matters that have gone to district court.
That you don't have possession of those records?
We are not part of that process.
Okay. And so those people who decide to go to district court, they pursue their own process in district court?
That is correct.
And so we're not getting anything?
Pardon me?
We're not going to receive anything regarding any, we actually asked about any employment matters. We actually asked related claims of sexual harassment, discrimination, retaliation, or any employment practice.
That goes back to the law. The law doesn't allow us to release anything to your committee. But if we were to change the law, then we could use the method through investigation by our general counsel. Any report that's generated where reasonable cause has been found that the law has been violated could be released to your committee.
And so let me ask you, as well as Ms. Lett, what are your opinions on mandatory reporting to the Ethics Committee in harassment matters?
I have to say that's a very difficult question to answer. When we handle matters of discrimination and we talk with our clients, we tell our clients that it's possible that we will resolve the case or the case may go forward, but there may also be some type of ethics matter that might arise out of those circumstances. So they will know that they may be fighting on two fronts, whatever the claim may be.
And can I ask, Ms. Grunman, in your letter, you state to us that you have encouraged employees who've been the victim that may constitute an ethical violation to contact our committee. How do you do that and to cooperate with our investigation?
We do that through the counseling period.
And is that just written? It's a written discussion, or do you provide them that in writing that they should?
It's generally, counseling is generally by phone or in person. So it's a verbal discussion.
And is there any discussion, and I'm sorry, my time is up, but my question was, is there any discussion about the confidentiality of the ethics proceedings in many ways? Not that initial investigations might not be reported, but in fact, very oftentimes the witnesses, the complaining witnesses, are often kept confidential.
I believe there is.
Okay, thank you. I yield back.
Gentlelady yields back. The chair will now recognize the gentleman from Alabama, Mr. Byrne, for 5 minutes.
Thank you, Mr. Chairman. I appreciate you allowing me to participate in this hearing. It's been very edifying for me. Mr. Crowley, I want to make sure I clarify one thing with you. I don't think you're saying this, but I want to make sure we get this very clear. You're not saying that the speech or debate clause provides immunity to a member or a member's office if they engage in sexual harassment.
Congressman, that's a very difficult question to answer. Clearly, the conduct itself is not protected. The question becomes what happens when a member of Congress asserts that the discriminatory action, which of course sexual harassment includes, was not motivated by what the victim says it was. Clearly, sexual harassment under any circumstances
but
is
that would not be
inappropriate.
sexual harassment then.
Well, keep in mind that sexual harassment is a form of discrimination under the
Yes, sir.
Civil Rights
It's a
Law.
subset of discrimination based on gender, but sexual harassment cannot be immunized by the United States Constitution.
That's correct.
Okay. I want to make sure we got that clear. Now, I want to move to what we do about it. And I think where we're really touching here is how we investigate and enforce this. Ms. Grumman, you do not have the authority to investigate or enforce that today in sexual harassment.
That is correct.
But if it was an OSHA case, you would.
That is correct.
Why would there be a distinction between OSHA cases and sexual harassment cases?
We have those same questions.
Okay. Mr. Crowley, you want to answer that question?
You know, Congressman, the honest answer is I don't recall. I do recall conversations around having the Office of Compliance play a particular role with respect to the ADA and OSHA because it was a case of first impression. These are historic buildings. If there needed to be retrofitting of an elevator shaft, for example, it was a more involved discussion. And so that was the reason that the OCC, Office of Compliance was given responsibility in that area. But why it didn't go further, I can't tell you.
Well, and I will say this. A lot of case law occurred in this area after 1995. I mean, we have the Farragher and Ellis decisions from 1998, the Onkyle decision. So a lot happened after that time that you wouldn't have known about at the time you were writing it. So, Ms. Lipnick, let me turn to you. You do have the power, whether it's with regard to people in the private sector or federal employees that don't work for Congress, you do have the power at the EEOC to both investigate and enforce. Do you think that the Office of Compliance should have similar powers when those sorts of things come up with regard to members of Congress or people that work for us?
The short answer is yes.
Okay. I like short answers. They're the best.
Again, as you well know, and you know, I thought your testimony from the November hearing was spot on. Again, there's this point I keep making. There's the difference between that immediate investigation that has to take place and that corrective action, and then you know, the investigation at the EEOC participate is when someone comes to us and we are investigating. Essentially, was there an investigation? What happened internally? What was, you know, the corrective action taken by the company? But someone needs to be doing that. And now, it's my understanding from the testimony that I read that the House Employment Council plays that first role in terms of investigating into members' offices. But I think it's certainly worth considering, do you want to have, you know, a third party, essentially, who's not then representing the members' offices later on in the process, conducting that initial investigation, and then also making some determination in terms of liability.
Here's a really sticky issue, and Ms. Lett, I'm going to look at you for this one. Now, in the private sector, where we don't have public disclosure issues, when we engage in mediation or we engage in settlement discussions and we reach an agreement, it's almost always confidential. Mediation rules require confidentiality, and then the settlement agreements, which are contracts, have confidentiality provisions in them because the confidentiality or the promise of it helps foster the negotiations, help foster people coming to a meeting of the minds. How do we resolve that tension here in the public sector?
I wish I had an easy answer for you on that one, Congressman. There is a tension there. Oftentimes, employees want that confidentiality because they want to go and they want to get other jobs. Certainly, members of Congress want that confidentiality because even if a member or the office has done absolutely nothing wrong, putting that information out into the public can certainly hurt. So I don't have an easy answer to that question. I certainly will give it some additional thought, but it's a very difficult situation.
Me either. Thank you, sir. I yield back.
Gentleman yields back. I want to thank each of the witnesses for being here today. You've given us some very valuable testimony to consider as we go forward. And I particularly want to also thank Ms. Comstock for her work on this. She has been invaluable to this committee and will be as we go forward. Also, again, want to thank Representatives Spear and Byrne for your previous testimony here on November 14th and your participation along with Ms. Brooke today as ex officio members, and appreciate that insight that you've given. We have a great responsibility to go forward to get this right and to make sure that we continue with the message that one case of sexual harassment is one too many. How do we make sure that the victim, as Ms. Spear has so eloquently stated, how do we make sure that the victim is protected? With changes that we will consider when we balance transparency issues with making sure that a victim is not a victim a second time because of any changes that we make. We want to make sure, with your input, that we make this in the correct way. It doesn't seem that difficult for members to remember the golden rule and to treat people with respect. And that will solve a lot of our future problems as we try to clean this up. I want to remind everyone that members that we have 5 legislative days to submit to the chair additional questions in writing that would be passed on to the witnesses. If we do that, we would encourage you to answer those as quickly as possible so that those can be made a part of the record. Without objection, this hearing is adjourned.
Good to see you, too. The devil is in the details. Your memory is pretty good, Dan. I mean, you kept qualifying.